The conversation that follows illustrates how people in the U.S. immigration justice system anger the baby immigration Frankenstein's monster that is already out of order. As if the immigration wall collapsing while those in need jump in is not emergency enough, those looking for the proper channels through which to get in are trapped on the wrong side of the wall and wait for hours for the government to hear them. The conversation that follows is an example of wrestling with the immigration monster. It is based on a real hearing that occurred on January 17, 2008, at the third floor of the Salt Lake City Courthouse, room W34. I am the plaintiff in this case, being someone who lost her status code because of a computer virus and code. I communicated as best I could with U.S. immigration but failed because the federal law does not provide remedies for foreign students when universities do not play ball. I, the plaintiff, searched the web for answers and came across Kimberly Trupiano, an immigration attorney. I asked Trupiano's firm to draft a letter of demand, to discuss the letter with her, and when the wording was agreed, to mail the letter to the university. Trupiano's firm collected $1,000 retainer fee to start with, and then later asked for another $2,000 for drafting a letter of demand to Weber State University. However, I asked the attorney for the $1,000 back because the firm did not carry out the assignment in the way that had been agreed. The attorney responded with a demand for more money, including fees for representing herself in court on this day of January 17, 2008. The judge read from the sheet, "Plaintiff. Who is the plaintiff?" "I am, Your Honor," I said. "How do you pronounce your last name?" I said my name for the judge. "The defendant. Your name is Kimberly Trupiano?" the judge asked. "With a stress on the first syllable," said the defendant. His eyes turned in my direction. Then he read from the summons sheet. "You say that for the $1,000 retainer fee she collected on an assignment, she and her office did not fulfill your requirement?" "Precisely so, Your Honor." "Tell me what happened." "Your Honor, the last time I attended Weber State University was May 2007 when I graduated. During my last semester at the university, which was fall 2006, I was told I could not register for classes because they said, been a computer malfunction. Because of this computer malfunction, I lost my F1 student status, including the rights and privileges that come with the status. It took about 3 months for the university to tell me the reason I was out of status. I filed for reinstatement to F1 status and was approved on May 7th, 2008. So, how do we get to the letter in question? I'm getting there, Your Honor. In the meantime, my application for OPT was still pending with USCIS. What is OPT? OPT is work authorization given to foreign students to work for 1 year on completion of their degrees. So they just let them stay here for 1 year regardless of what they are doing? No, Your Honor. The work the students do is related to their fields of study. USCIS responded with a request for 2 items. Item 1, USCIS wanted the international students DSO at the university to call the Immigration Help Desk to fix problems relating to my initial loss of status, and then issue a work I-20 signed by the DSO and me. The DSO refused to carry out these orders and sent me to Senator Hatch's office for help. I looked for help on the web and ran into Trupiano Law Office. I took the request to the defendant's office and asked her to demand on my behalf the evidence USCIS was looking for. The specific plan was for the defendant to draft the letter, for us to talk about the letter, and then if we agreed, mail it to Weber State University. I have a set of documents here, Your Honor, that explain the stages in the process I just told you about. May I bring them over to you? If you don't mind, let me hear what she has to say first. That's okay with you, right? It's okay, Your Honor. The defendant said, Your Honor, I spoke with WSC officials as we had agreed. I did research on the issue. This is a copy of the plaintiff's file that I read and made notes on. As a matter of fact, the university officials were willing to resolve this issue with my client, but she refused to attend because in her culture, you cannot call a person to a meeting without an agenda. I was trying to mediate this process so that we would eventually get her status up and running and also get her OPT as we had planned. The money she's suing for is not hers. One Dr. Quicks called in to pay the $1,000 for her on his credit card. You mean as a matter of administrative procedure? I see. I had to say something here. Your Honor, how I got the money to pay is not relevant to the issue before this court. Besides, I have an email here in which the defendant says she did not doubt the origin of the $1,000, and she even acknowledged that sum by saying she needed an additional $2,000 for the assignment I gave the office of drafting the letter and for us to talk about it and then mail it to WSU if we agreed. The issue of Dr. Quicks is not relevant. I paid him the $1,000, and the details of this payment are not relevant to this court either. You paid Dr. Quicks? Asked the judge. So, what does that have to do with anything? I paid back the money the defendant says he paid for me. So the money in question is mine. Oh, you refunded the money. I see, said the judge. Then he said to the defendant, did you bill her for the work done? Yes, Your Honor, but my secretary told me she left the bill at the office when the plaintiff was there to pick up her documents. I sent her several other bills in the mail which she ignored. Your Honor, I was never billed by the defendant's office. Only she told me in the email that she needed $2,000 more. I have the email here, Your Honor. I can bring it over to you if you wish. There was a pause. The judge did not say it was okay for me to show him the email, so I read the section that referred to the $2,000.